The Colorado Civil Rights Division enforces the Colorado Anti-Discrimination Act, otherwise known as CADA. In this video, we will explore the complaint process and how potential acts of discrimination are processed by our division. Let's begin. The Colorado Anti-Discrimination Act, otherwise known as CADA, makes it illegal to discriminate on the basis of protected class in the areas of employment, housing, and places of public accommodation. The first step in filing with CCRD is the inquiry stage. Anyone who believes they have been treated differently based on race, gender, national origin, sexual orientation, or another protected class can visit our website at ccrd.colorado.gov, give us a call at 303-894-2997, or email us at dora_ccrd@state.co.us. After learning more about CADA, anyone may move forward with an initial complaint inquiry by filling out an intake form using one of the following methods. Starting an intake inquiry online at ccrd.colorado.gov, obtaining a paper copy of the intake packet via mail or email, or by visiting our Welcome Center kiosk to fill out an intake inquiry or pick up an intake packet. An intake packet must be fully completed before submission. Please note that you do not need an attorney to move forward with a complaint of discrimination with CCRD. Now we will move on to the intake stage. Once an intake inquiry has been submitted, it will be assigned to an intake specialist. The intake specialist will review the inquiry for jurisdictions subject to CADA, meaning, based on the information submitted, does CCRD have the power, right, or authority to begin a formalized charge of discrimination and investigate the allegations? The intake specialist will look for the following. Is the protected class covered under the Colorado Anti-Discrimination Act? Do the dates fall within the timeline to file a complaint? And does the employer, housing provider, or place of public accommodation operate within the state of Colorado? If the answers to these questions are yes, the intake specialist will contact the potential complainant to set up a phone interview. The intake specialist will then use the information gathered from both the interview and the intake packet to draft the complaint of discrimination. The intake specialist will then send the draft of the complaint to the potential complainant for review and signature. Once signed and submitted back to the division, the complaint is considered officially filed with the division. The official filing date is the date the signed complaint of discrimination is returned to and received by the Colorado Civil Rights Division. The complaint will then be sent to the business accused of discrimination and will be considered served. An important reminder: the filing date is the date the signed complaint of discrimination is received by the Colorado Civil Rights Division. Once signed and submitted back to the division, this is the beginning of the investigation process and not the date of the submission of the intake inquiry. Please note that the division has 450 days to complete the investigation process. Filing deadlines should be taken into consideration to ensure the division has jurisdiction over the claim. CCRD encourages anyone who feels that they have been discriminated against to contact CCRD as soon as possible so that formal filings can be processed before the filing deadlines. Once a complaint of discrimination is served, parties are notified in the RFI or Request for Information packet of the option to participate in voluntary mediation. If both parties agree to voluntarily mediate, a mediation conference is scheduled. CCRD has free mediation services that are available for use and will assign a mediator who will schedule a time for the mediation conference that works best for both parties. The mediation will take place over the phone or over Google Meet. If the parties are able to resolve the complaint with a settlement agreement, the case will be closed. If the parties participate in mediation and a settlement is not reached, the case will proceed to investigation. If either of the parties do not volunteer to mediate, mediation does not occur at this stage in the process. Once a complaint is filed, the case will then leave the intake unit and go into investigation. CCRD will serve the complaint of discrimination along with the request for information, or RFI, to the named respondent, the business that is being filed against. Once the respondent receives the charge of discrimination, they have an opportunity to submit their response, also known as their position statement, provide responses to the RFI, and submit any supporting documents. The request for information is a list of questions that the respondent must answer and provide supporting documents. The complaint will also receive a copy of the charge and the RFI. That is how the complainant will know that the respondent has been served. During this step in the process, an investigator is assigned to the case and will reach out to both parties to introduce themselves. Depending on the type of cases, there are different deadlines to respond to a charge. In employment cases, there is a 30-day deadline to respond. In housing cases, a 10-day deadline to respond. And in public accommodation cases, a 30-day deadline to respond to a charge. Once the investigator receives the position statement from the respondent, they will review it for completeness. Once it is determined that the response is sufficient, the investigator will send that information to the complainant, who will be given an opportunity to provide a rebuttal statement. This gives the complainant the opportunity to respond to the position statement and provide additional information to the investigator. Once the investigator receives a rebuttal, they may decide to interview any witnesses for either the complainant or for the respondent. The investigator will analyze all of the information provided during the investigation. Once the information is analyzed, the case will be submitted to the director or an assigned designee to make a determination on the case. Please note that the division has 450 days to complete the investigation process. Filing deadlines should be taken into consideration to ensure the division has jurisdiction over the claim. CCRD's director or the director's designee will then consider all of the information presented. The director will consider all information presented in the investigational packet and make one of the following determinations. PC, or probable cause. This means that there is sufficient evidence to support that discrimination, harassment, or retaliation did occur. NPC, or no probable cause. This means that there is not enough evidence presented to determine that discrimination, harassment, or retaliation occurred as alleged in the complaint of discrimination. Mixed finding. This means that probable cause was found on some, but not all allegations. In these cases, the PC portion of the complaint moves forward and the NPC portion of the complaint is dismissed. When a complaint is dismissed, the complainant receives a notice of right to sue and may pursue their case in civil court on their own or with the services of their own attorney. If a complainant receives a letter of determination that states that there is an NPC or no probable cause finding, The complainant has 10 days to file an appeal to the Colorado Civil Rights Commission for reconsideration. The Commission will consider the appeal and issue one of the following decisions: no probable cause, which affirms CCRD's determination of no probable cause and will serve as a dismissal. The Commission may request additional investigative information from CCRD, or the Commission may reverse CCRD's determination. If the case has been issued a probable cause determination by CCRD, both parties are required to attempt to settle the case by conciliation. Conciliation is a mandatory mediation where both parties must attempt to settle the complaint, if possible, with the caveat that the case will possibly be referred for a hearing before a judge. If conciliation fails, the Civil Rights Commission will consider referring the case for an administrative law hearing. All fair housing cases are automatically sent for hearing. If a case is presented in an administrative hearing before an administrative law judge or ALJ, the results and ramifications of that case will be determined by that judge. We hope this video helps to explain how a complaint of discrimination with CCRD moves through the division's investigation process. For additional information, you can visit our website at ccrd.colorado.gov. You can call us at 303-894-2997 or email us at dora_ccrd@state.co.us.